All right, so we are live. So hey everyone, I'm Anubhav Garg, a management trainee at LawSikho, and I welcome you all in our today's session, Information Utility under IBC, everything you need to know. As a subject matter expert, we have Somya Singh ma'am with us. Somya ma'am is the founder of Avant-Garde Communication, which is a company providing service in public relations, public affairs, and experimental marketing. They also deals with legal consultancy, media monitoring, research analysis services. She has more than 5 years of experience, and her main areas of expertise are IBC matters, real estate matters, debt recovery, and clientele and PR management. So thank you so much, Soumya ma'am, for being here. It's an absolute pleasure for us to get an
Likewise,
opportunity to learn from you.
likewise. So, Anubhav, I think I would like to start with congratulating the entire team of LawSikho, because since human race has begun, we have only aced in our respective fields when we have been able to turn our adversities into our opportunities. And during this pandemic, this is what exactly LawSikho has done to us, with having this variety of webinars with such vivid kind of topics. I think this is the best utilization anyone who has access to your webinars has got. So thank you for us for enlightening on so many topics that you could touch in such short span of time. And yes, I would like to do the same today to all the listeners and viewers that we have right now and who will see the YouTube later. So what we're trying to do here is, before going to the main topic as to how information utility is a key pillar, as I've been told by you the last time we had a conversation, that we would be having students and people who are into advanced stage of their courses, and we might be having people like who are practicing CSCA lawyers or corporate counsel. So I'll try to keep my content in a way so that it is helpful for anyone and everyone who's watching the video.
All right.
Uh, to start with, I think if there are certain questions that you have in mind, you can start with, or I can start with the basis of information
All
utility.
right. All right. So people, how we have planned to go about this session is I have some set number of questions with me, which I will be putting to Soumya ma'am. If you guys have any question, you can type it in the chat box, and if I find them pertinent to the topic we are currently discussing on, I will again put it to as a follow-up question to Soumya ma'am. So I think we can go like this so that not everything goes haywire, because not all the questions are relevant, and if they are relevant, they are not relevant to the current part of the session. All right, ma'am. So,
Absolutely.
ma'am, jumping into the nitty gritties of the topic, how about we first know a bit about our expert? Can you please tell us your story as a lawyer till now?
Okay, so I'm a first generation lawyer. I did not have any godfather. I completed my education from Campus Law Center, Delhi University, and one college that gave us opportunity to be in proximity with the apex courts, several tribunals, adjudicating authorities, 7 district courts, and of course the High Court. So we had a lot of choices to make as to which direction do we move forward to in order to choose our career paths. And one can't be mastering all of it, jack of all trades, master in none. Although I think every lawyer is super wide in its experience and knowledge when it comes to, because there are only few at the top who are dealing with particular kind of
Yeah.
cases. But when you are at the initial years of your career into litigation, you need to know something of everything and everything of something, and that usually helps, this theory. So what I did was I practiced under senior lawyer Mr. Avant-Garde, who deals into economic offenses and financial crimes, who took a lot of high-profile PMLA matters, and it got me intrigued into economic offenses and financial crimes. And eventually, after 1 year of learning and churning and practicing under him, I started my own practice in 2016. And since then, yeah, I've been flying solo. I've been trying different kind of cases, from criminal law to civil to matrimony to real estate issues to eventually coming down to, and finally trying to get my refute in IBC, in NCLT matters, company matters. So to everyone who is just starting or has started off late or is about to begin, I would just say that if you can enhance your knowledge by increasing your tenure under a senior lawyer or a simple lawyer who's got a good practice at any level, it is a good advice to go with. If not, it is always good to kickstart. All thanks to platforms like LawSikho, they have so much to offer that you just need to have a good internet connection, sit at home and learn everything and everything, anything and everything that you want to. So yeah, that is how
Thank
it
you
is.
so much. Very kind and insightful words. So ma'am, now addressing the elephant in the room,
Yeah.
what is information utility and how significant is it for IBC filing?
Okay, so straight away going through, the main topic, I would like to give a little basis of what made IBC, being so significant in, such short span of time of 4 years. Like it was just introduced in 2016 and 2020, and we have so many cases, so many ordinance being passed, suspension of IBC, so much havoc in the news these days. What happened is, if you go by the record of last 30 years, Anubhav, the kind of legislation that we have in banking laws, economic offenses, and financial crimes, you get to see SURFACE, you get to see DRT, you get to see PMLA. There was legislation scattered under different acts and procedural laws. There was absolutely no integration to it, and it was also an opinion that any kind of law, be it commercial suits, be it any debt recovery tribunal cases, or any writ being filed before the High Court, it was tilted towards the debtors, because we all know how many years it took for a financial creditor to even establish his debt, and let alone default of debt. After having IBC, we have just one umbrella under which we have rights of the financial creditors, rights of the operational creditors, rights of the debtors himself, especially with the introduction of IU, where the voice of the financial debtor, the company debtor, is also opinionated, and it is taken into consideration, and it is authenticated, verified, and only then it is given a tick mark, good to go. So we have IBC, where we have, in the words of Mr. Pawan Kumar, Executive Director, IBBI, it is actually comprising of 4 pillars, which has, of course, the adjudicating authority, which has NCLT and IBBI, which has insolvency professional, and the fourth and the very important, which we are going to discuss today, is the information utility. Now, there comes a question: what makes it so exclusive or so significant? Anubhav, it takes immense pride for me to discuss something which is not borrowed from British laws, which we have been just amending for over more than 1.5 centuries, and just trying to, adapt to it. This is something which is one of its kind.
Yeah.
Information utility is a repository.
Yes,
It is a repository of information being collected, authenticated, verified, and then given access to the stakeholders, which is one of its kind. Insolvency laws across the world is very stringent, but they do not have a collective information forum which has it all. You just need to have an ID and a password and access, and you get to see the information related to your debtor. None of the countries have it. India is the first one to come up with a platform of this sort. So definitely it gives me a pride. Also, for the reason that if you go by not long back, just the recent years, we get to see the non-performing assets of the countries are taking, a steep high losses to the banks, and how it has just been increasing every quarter, despite of the efforts being made by the RBI, given by the finance ministry, so many ordinance being passed. But then in order to curb the non-performing assets, we needed a platform where both the financial creditor slash operational creditor and the company debtor is put at par, where both the parties have their say, where both the parties can authenticate their information, where both the parties can, if they have a dispute, they can counter it, question it, resolve it. And the ultimate result of it being, it reduces the time, energy, resource, money wasted in legal disputes. So IO is that one platform which is taking information from one party and giving it to the other party, and ask, this is your financial creditor. He has given a certain information about a default. Do you agree to it? If you don't, then of course there is a medium to it. You can always resolve it. So IU can be put together as both the things, like a dispute resolution system for financial creditors slash operational creditors and the company debtors. And it is also an evidence bearing instrument, because it also takes into consideration that the information that is passed on. Now, you all, this generation belongs to technology. You are a generation of technology. This is what our litigation has adopted. It has been nothing but a platform made on a technology basis. It has its own pros and cons. At one place you have, just plug into your laptop, have an ID and a password, and any person, any legal counsel, corporate counsel, insolvency professional, any lawyer who wants to know the credit health of a company can just log in at IU NECL, that is National E-Governance Service Limited, the first company made under IBBI, which is working as an information utility company, and he can know every information about XYZ any company before running from pillar to post. It also brings into notification that we had such kind of credit rating companies before. Like a very familiar term to everyone is CIBIL. Everyone knows, अच्छा CIBIL score कैसा है, बैंक लोन नहीं देगा अगर CIBIL score कम है. You don't mind if I am bilingual, right? It's okay if I explain few things in Hindi, because it gives that.
There are some people who are here and they are from South India. So
Oh, great.
I don't know.
Okay, I'll make sure. Okay. So every one of us are very familiar with the term, even from a non-litigation background, that one must keep the civil score high. But let me just tell you, civil score is one-sided. It is the information collected by the company, and they have done this rating, and they give it up to you, which can be disputed, which can be challenged, and thus information utility becomes at par, because it is an authentic information. It is a platform which takes the information from one entity and it reconfirms from the other entity. Only once it is reconfirmed, then it is authenticated and made access to anyone and everyone who wants to have information. Now you must be familiar with the term known as DigiLock. A DigiLock is an app that secures and saves all of your data. When it comes to your birth certificate, your 10th certificate, your Aadhaar, your PAN, and your data is safe. Now they do not have access to your information. It is just a cloud, iCloud, where you can just save your information and you know that it is safe. IU does the same for the financial information of any company, to put it in a simple sentence.
I understood.
Once it is done, it cannot be disputed. It only does, what it does is, when you get into litigation, be it a commercial suit, be it a writ before the High Court, be it DRT or any other forum that you may pick, it takes years, as said before, it takes years to establish the fact. What IU does for you is, it is only furnishing the established, authenticated facts before the court, so that the litigation process is expedited by many folds.
All right. So now we have understood what is information utility and how significant it is, what it does, and those things. Our fundamentals are clear. But ma'am, a very obvious question comes to my mind now. When and how does information utility become a key pillar in the IBC, in the currently persisting IBC ecosystem?
Okay.
Yeah.
So let's not even try to explain certain landmark cases, if I may call it, because I think it will be the most controversial cases. Vijay Mallya, Kingfisher, or Nirav Modi, the PNB scam, all of this, and then several thousands of other disputes that you and I are not familiar of. These were the most highlighted ones. Let us just go back and see what happened in the late 90s when it came down to all these scams related to the stockhold, the marketing, the shares, the debentures. What happened with the banks? What happened with people who had, for example, to be specific, in the case of Vijay Mallya, 17 banks had provided loan to this single entity, and he just managed to take just 17 bags and get vanished and be out of the country. We needed a platform. We needed a platform where if there are array of say financial creditors, and when I say financial creditors, I mean the banks, the NBFCs, even companies that are taking public deposits, debenture treaties, anyone who can be put into the category of the financial creditor needed information as to how the company or the entity used to work before, or how is it going now. Should I put in more money or not? This country is growing some fabulous startups. We have more than 15 unicorn startups where the turnover is across 1 billion. Now imagine if there is an investor and who wants to invest, but there are all news that China and India is having a dispute, there is a pandemic going on, there is economic slowdown in India, should I invest my money or not? Now how about having a platform where I can just have access of, say, for example, Oyo. I want to invest in Oyo, and despite all these things happening in India, I would want to be specific whether what kind of financial stage information. And when I say financial information, the assets, the liabilities, the defaults being made, balance sheet, cash counting, all of this. What if I get access to all of this at one platform, which will obviously help me a lot in making a decision as a financial creditor / as an investor, should I be investing into this certain company or not? Or for a second example, supposedly there is a lot of FDI, which has of course happened in 2019. We have more than $15 billion of FDI being invested in India. Supposedly there are more investors in the row, and they have already invested in certain companies of India in bits and bits. They want to know how is it the entity or the company going presently. Suppose I have invested 30% of the amount promised, and I want to invest 40 more, but I would want to know how's it going. What is the equation between the operational creditor and the company debtor? What is the equation between the company debtor and other financial creditors? Because just like Malia, there are people who do not get restricted to just one financial creditor. We have banks, we have NBFCs, we have so many sources to raise funds who can come into the category of a financial creditor. So as one financial creditor, I would be inquisitive to know that, what is this particular entity doing with the money invested by the other financial creditor? And if I get access, and if I get to know that there has been dispute, I might just raise my guards and might not invest further, or maybe ask for an inquiry. For that matter, you will not believe, information utility has something sort of a broadcast list, as we have in WhatsApp. Yeah. We want to send a similar message to a number of people in one shot. Yeah. We have a similar kind of setup in IU as well, where all the creditors will be passed on an information. A report will be passed on to everyone that this particular debtor has defaulted with certain financial creditor, and it is a default of say XYZ amount, and it will be passed down. So much so that every creditor also not only has the right and access to all such information, he also has a right to pass on a comment if he wants to. Now, this might just sound like, very barbaric towards an entity or a company that, all these financial creditors might just pounce on me and will not give me to tell my share of story. Fortunately, this is what makes IU more exclusive. What it does is, it gives opportunity to the debtor. How it works is, the modus operandi of information utility is, first of all, a financial creditor. Let us take example of a company. Suppose, if you don't mind, I'll take example of LawSikho. Sure. State Bank infuses 2 crores of rupees in LawSikho. They wanted to broaden it globally and make it bigger and better each day and every day. Suppose there is a default. EMI payment, some loan, some financial default in payment. Okay. Yeah. Now what SBI does is, it gives all the information at the platform of NECL, stating that LawSikho took 2 crores from SBI. It managed to pay us 1 crore 10 lakhs, and it has defaulted in its last 3 EMIs amounting to say 50 lakhs. Now what happens is, once this information has been put at the platform of NECL, the acknowledgement, the representation, the information goes to LawSikho, where LawSikho is being told thrice, not once, thrice, in the gap of 3 days. If you respond day 1, good enough. If you don't, there are 3 notices being sent, and the entire process runs into, say, a span of 14 days, whereby they ask that, SBI says that you have taken up loan for 2 crores, you have paid 1 crore 10 lakhs, you haven't paid last 3 EMIs amounting to 50 lakhs. What is your say on this? Now, once this information reaches to LawSikho, LawSikho also has its own rights to tell their side of story. How do they do that? What they do is, so first of all, we need to remember at back of our mind, it is all about technology. So we have digital signatures as per the IT Act 2000, Information Technology Act 2000. And we know that the authenticity of digital signature cannot be challenged. 2, we have verified email IDs of the representatives of an XYZ company, LawSikho in our case. So what they do is they send a notice, and you must be knowing, Anubhav, now these days even a double blue tick of WhatsApp is deemed to be read and received by certain courts.
Yeah.
So we are getting advanced day by day. So what is done is we are sending the email to LawSikho saying, boss, you have paid this much amount so far, but then 50 lakhs is due. Tell me if this information about the default from your end is true. What LawSikho can do is, there are 3 options. Supposedly, LawSikho agrees to it. LawSikho says, yes, I accept. 1 crore 10 lakhs has been paid so far. 50 lakhs has been, in the middle of nowhere. I've been unable to pay due to certain business problems, let's say because of the pandemic. And the rest of the amount, that is 40 lakhs, has to be paid in future. As soon as LawSikho says yes to whatever has been passed by SBI, the status of the default under IU becomes authenticated. And it is represented by a color, green color. It is not about, this is not whims and fancies about my mind. It is there in the regulation. Okay. So the green color is given, which reflects that the information about the default given by the financial creditor SBI has been authenticated by LawSikho, and they agree and pay nod to, yes, such default has happened, and it might, give a rise to a legal dispute in your future, and thus it is authenticated with green color. Now, situation 2, LawSikho disputes the information. They say that no, there has been absolutely a misinformation on the part of SBI. We have not paid 1 crore 10 lakhs, rather we have paid 1 crore 35 lakhs, and there is only 15 lakhs amount left. In that case, the status shall be disputed, which is red in color. The third condition is, if LawSikho does not respond, which as Indians we are an expert to do so. We will not pick up calls. Oh, I did not see my email. Oh, I had no access. I was traveling. All such things have played, excellent roles when it comes to cases under DRT or commercial cases and all of that. Things have changed. It's a different ball game altogether. Now you can't mess with, things as advanced as IU, where they say, okay, maybe you haven't been able to give answers on day 1. I will send you notice after 3 days. I will send you a third notice after 3 days again. And if you don't reply, I will presume you have agreed to the dispute and you're sleeping on your rights, and you will not be given a chance to refute it later in the court, so that you buy out time here and you buy out time there. And the status becomes deemed to be authenticated, and the color given is yellow.
All right.
What is happening here is, what IU is trying to do is, literal and figurative sense, I'll tell you both. In literal sense, what it's trying to do is, let us just come down to the crux, that is the amount of dispute. the nature of dispute, the span of the dispute, the repercussions of the dispute on the finances of the company, and the equation between the financial creditor, by giving a concrete information which decreases the gap between dispute being established and remedy being given to the financial creditor. They have squeezed down the time slot. What they've done is they have made adjudicating authority, NCLT, in a much better position to let the appeal or application be admitted in one go. As soon as they give us the evidence bearing instrument, that is IU, you just need to download the PDF file of the financial report of LawSikho and go there and say that LawSikho hasn't paid. It has not even answered, so we are presuming that it has authenticated. And so I get a quick poll question here. Can I just shift it? I'm not part of this poll, right?
Yeah. Oh, yeah, you are subject matter expert.
Okay. So what we can do is the time gap is squeezed, and the application gets admitted, which used to take years even to admit the dispute. So we are saving our time, energy, everything. And in figurative sense, how it is helping is, it is pushing the entire country towards credit discipline. It wants to give a deterrent effect to people who had this tendency to take loans and have several personal guarantors and flee away with the money and say that, I had some bad business decisions and that is why my money is gone in vain and that is why I won't be able to pay. So what it does is, it gives a deterrent effect, and that is why I know that my digital signature has been put on record, and that is why all the information that I've been giving so far about the dispute, I cannot retreat now. So as per section 18, acknowledgement of the debt is already been done by the third party.
Section 18 IBC?
No, Limitation Act. For section 18 Limitation Act, where you need to have the acknowledgement of debt, and there is a duration to it, right? As soon as one has given information, as soon as the corporate debtor gives the information, the task is done. The acknowledgement of debt is done. You just need to furnish the evidence before the court, and you need not do anything further. So that is how it expedites. And in a country like India, we need laws like this where we can expedite the legal system and procedural, all these things under the law. You must be noticing that IBC, because of this, becomes both substantive and procedural in nature.
Yeah.
It might just feel that it is procedural in nature in one shot. But as far as the rights of the financial creditors are concerned, also the company debtors, it is a substantial law because if you see the ripple effects, it's strengthening the economy. It is strengthening the economy. It is encouraging the investors that, I have an authentic report. The ease of doing business has become easier because this cannot be disputed. I can just have a black and white whether I want to invest or not, whether I want to go to the court or not, whether I want to have any chemistry with such company debtor or not. So it makes it, binary system, 1 and 0.
All right, ma'am. Understood. Very comprehensive yet very precise answer. Wonderful, ma'am. So, ma'am, a question has been asked by Janardhan sir. Access to IO information. ये question है, तो मैं से question की तरह पढ़ूंगा. Is access to IO information is available to third parties also? As for example, lawyers who are checking the title of any property or credit liability of any party who is dealing with his client.
Okay. So that is why I said, so there are two things, yes and no. Yes, because anyone can have access. You just need to log in as a user at NSCL website. If you are a home buyer, if you are a financial creditor, if you are a company debtor. Now, supposedly, I just take the present example so that it explains everything. LawSikho also have a council, right? It has a corporate council which takes care of all the legal disputes of LawSikho, correct? What an irony, LawSikho has a council. Anyway, so what he can do is he can tell his share of story, and that is why he needs to access as to what information my financial creditors has, feeded at this platform. So he being one, financiers and investors can also get into it. Supposedly there is a dispute, the insolvency professionals can also have access to it. A third person can also have access to it. You just need to log in as a user. But then as far as searching of the title of the property is concerned, this is not about the property, this is about the financial information about of a company. So it is about the liabilities and assets and defaults and cash balance and the balance sheet of a corporate. It is not about the property just in specific.
Understood.
Now, for example, if it is a real estate company, then it will work because all it deals is in properties. And if there is, and we are seeing a lot of cases coming up as far as these home buyers are concerned. Lot of home buyers are rushing towards, NCLT in order to go against such corporate debtors. What went wrong was these corporate debtors picked up, funds from people, picked up funds from one bank, did not complete their project and invested it into the other project. Say A project is, they've picked up money for A, did not complete it, invested half of the money in B, made little construction, raised money from B, put it into the C. This is what happening. IU will curb this. Day one, when you do not have your deadline being met from the point of view of a home buyer or from a financial creditor, you can always have access and you can feed in the dispute, the default that, these real estate company whom we had, invested so and so amount so far has been unable to pay the amount, or there is a financial dispute. Now, as soon as this happens, the other person or the other financial creditors whom, will be getting the access of the information on IU will be broadcasted such information, and they will raise their guard saying that, okay, maybe now I don't have to invest. Or as a home buyer, if I get to know it about, say, Amrapali, that Amrapali has not delivered on time or Amrapali has not paid its due, then I might just not invest. Yeah. And that is why, as a common person also, if I want to know the information, and let me just tell you, there are certain datas. More than 76 lakh crores of data has been saved in IU already. A circular was passed in December 2018 by RBI, whereby all the banks were asked to pass on the information regarding their creditors. So let me just tell you, NECL is nothing but a union government company which is comprising of 13 banks, 3 insurance companies and 1 debenture treaties. So what they've done is they have asked the bank to pass on every information, of course not in, of course in a retrospective effect as well, about the individuals, about the corporates, about the individuals in corporates, so that we can have access. Now, of course, partnership deed and LLPs are still, a huge area that needs to be covered. But what has happened is so much data has been fed so far, and more than 600 cases have actually used the information of the IO. What important point that comes here is on 12th of May 2020, the principal bench has also passed an order saying that, and it is very useful for people who are, about to get into IBC cases or are CS or CA or practicing lawyers or into a legal counsel of any NBFC or are legal counsel of any banks. It is now compulsory to furnish the information about the corporate debtor which is there at the IO. You need to fetch that information about your corporate debtor because it has already been put by the banks. And you have to furnish this along with your section 7, otherwise it will not be admitted. So the NCLT, IBBI, everyone is also pushing towards the fact that, the picture should be crystal clear. Let's not waste time if you have messed up. Let's agree to the fact that we were one of the most lenient countries towards our debtors. They always had that blind spot and then be done away with, which led to, of course, money laundering, corruption, and then slowing down of economy. It has ripples effect. Everything is connected. It's a vicious circle. Now, this one thing has been a key pillar because it is going to break that vicious circle. It is going to, break the elasticity of the fact that I can stretch it for an indefinite period of time and then pack up my bags like Mr. Malia and just flee away. it will break that, because you have information, and it will deter people from, putting in any further investment. Or maybe, if I want to take certain action against you, I can always take impact, because any investor would want to know the present working of the organization. How's it going? How healthy is the company? Which direction is it leading to? What about the profits? What about its operational creditors? Are there buyers standing outside? Is company leading to a sick company or something? So if I get all that information, it makes my decision making fast and accurate. Financial decisions, to be specific.
Understood, ma'am. So there has been question asked, which is totally relevant. What happens when IU records are disputed? Ma'am has already mentioned it can't be disputed. All right.
I can repeat if you want me to. What is
No,
what?
no,
I could not hear the end part of the question.
Yeah.
Is it covered?
The question is, what happens when IU records are disputed? But you have already told us that it can't be disputed.
Yeah, it cannot be disputed.
Yeah.
Either you could tell your side of story, as I said, that no, LawSikho has not only paid 1 crore 10 lakhs, it has actually paid 1 crore 35 lakhs. Either you tell me this, or if you don't tell me this, I'm presuming that you're accepting it. What they're trying to do is they're trying to cut the cord where I just buy out time by saying that, I might have furnished the wrong information. You cannot do that because your digital signature is there. You cannot refute. Or I can say that I did not get information because you have your verified email IDs, registered address where the notice is being sent from NECL. So they're trying to actually, these loopholes, they have cut down the loopholes to make it with precision.
Some has asked, can advocates access the information at IU? They can. Ma'am has already answered that.
I would like to add on to this. If you are a corporate counsel for a financial creditor, like some bank, you must. Any NBFC, you must. You are in some startup, you're a counsel in some startup or crowdfunding company, you must. Let me just tell you something. In time to come, Anubhav, there will be a time where having access and having a report of the IU will be part of due diligence and compliances. No company will move forward without having the information of IU, because it is so concrete and absolute in its manner that it can never be disputed, and it will be like a building blocks for people to have faith in companies to invest, and then of course take it from there. So it will be part of due diligence very soon. They are also working on a fact that so we had provisions under the Companies Act where one can always complain about the mismanagement of the company. Very soon under IBBI, we'll get to see that not only financial disputes, we will also get to see the mismanagement, if at all it happens, would be put on the portal, and the companies will be given chance to either refute it, give their explanation, or be silent and face the repercussions in the NCLT.
Understood, ma'am. So, there is a question which has been raised multiple times in the chat box: where and how we can access the information utility? So, basically, they are asking.
So, let me just tell you the difference. Information utility is a repository. It is a platform. Correct? It is a platform. Where do I get it? The first company that is registered as a union government company under IBBI is National E-Governance Service Limited. Any company having a turnover for more than a capital more than 30 crores can become an information utility company. Okay. This is the first and a single company till now. You can always go on a website of NECL, and they have FAQs where you get to have answers of basic questions. And after that, you'll see they are having a login of as a home buyer, as a company debtor, as a financial creditor. It is very easy. There's a website and you can always go to it. If you want, I can send you the link. Maybe you can put it in the description later for people to have access to it.
Yeah.
And yeah, the information is that's authentic. And also for a fact, for the storage, they have very minuscule fee. Like 12 rupees MBP or something like that. Very minuscule for 8 years, which is very minuscule, because as a lawyer and as a practicing lawyer, I can tell you it takes so much of amount only to maintain the stationery. The last case that I got into was running into 8,000 pages. in 41 volumes, and I had to make 4 copies to it because 2 were to deposit in the registry. I had to keep 1 copy and give 1 to the opposite party. So it ran into, say, on an average 8,000 into 4, 30,000 pages. So you can understand how technology will help us have more trees, more sense, more legal dispute being resolved, and less of nonsense.
All right, precisely, ma'am. Great answer. So, okay, we are having a lot of questions, but let us go by the flow of the questions so that things don't get helter skelter. So another question, ma'am, is what are the modes of operations, that you put it, modus operandi of IU, and how does it contribute to the dispute resolution mechanism? You have addressed the dispute resolution part to a lot of extent, but if there is anything to add on, you can. Yeah.
Okay. So what happens is dispute resolution mechanism in a way, because it gives us a platform where the two parties can come down, share their information. If they have any confusion, any contradictory information, they can always sit down and resolve it. We had such provisions earlier as well. Someone might say that we already have, arbitration proceedings, but let us just accept for the fact that arbitration proceedings are very costly. We end up paying to the fees of the arbitrator, and at the end of the day, either of the parties not happy with the award, and then they eventually move to the court. I'm not questioning on the working of the arbitration proceedings, but then definitely IBC has an upper hand when it comes to dispute resolution mechanism. What they do is they actually prepare a report and they send it across. They send an alert. If I, as a corporate debtor, do some faulty, financial decision, and it has been raised by one corporate financial creditor, then the rest of the financial creditors also get to know about it. And this is the reason why they'll be deterred from investing further, or they might just question as to what is going on. The corporate debtor will have that pressure on himself either to resolve it as soon as possible or face the consequences, because he might lose his further financial creditors as well. So what it does is, all of this happens very usually, but it happens in the court. It takes time, it takes a lot of resources. What it happens here is, it happens for free, it is hassle free, there is no say adjournment to it. There is no running away from it. No authenticity could be challenged, and that is why the dispute resolution mechanism here is faster, because what they do is they actually send the credit facility report. IU does the credit monitoring by not even being part of it. It is almost like Uber not owning a single taxi, but making one of the biggest traveling company or a forum in the world, where you can come up with your own taxi and somebody can hire it and it can be done. And this is how IU does not get into your data. It never does. It only maintains, authenticates, stores, and give access to whosoever wants it to. But the platform itself is so concrete, because it also gives the chance to the other person to tell his side of story. People trust on this platform, and people will. It'll come more into use after 12th May of 2020 order. People trust this platform more than anybody else. And they also have this fear in mind that, the debtor under regulation 23 of IBBI regulation has given the consent. If I back out now, it will only, spoil my credit data. Let me just tell you, it is the largest credit data in the country. Every bank has been asked to put in the information, and for this reason, what they've done is, rather than fighting in the court or any other platform, let us just finish it here. You cannot back out. Come up with the better information, because it will only help you in further working. I might be laying on a lot of stress on financial creditors, but let me just also tell you, it is a great help for operational creditors as well. You must be seeing around why IBC had to suspend the filing against insolvency for 6 months, and after 17th May for 1 year. Because in such times of pandemic, all these small scale or medium and small scale enterprises faced a lot of hardship. They presently are facing a lot of hardship, and in that case everybody wants some amount to be infused. I don't know how 20 lakh crores is going to be beneficial. Not that I'm questioning the announcements of the government. All I'm trying to say is, if I have a good report card, I can always say that I'm going through tough times, but this is my report is as per the IU. I have a clean sheet. I have no red or yellow marks. I have only green marks. And I accept the fact that, yes, there is one dispute with this financial creditor, and which is not like hanging in the middle of nowhere. Rest, my profile is good. We are trying to solve resolution with this particular financial creditor, but then this should not stop you from investing further in my company, or, funding me further. And in that ways, people can also realize that, there is absolutely no blind spot into whatever is being told. That is why dispute resolution has come up to a very one-on-one fact, where there is no complexity to it. Either you have done something wrong, accept it, move further, so that we can also help you in reviving your company, or go ahead and maybe face insolvency, and if not, then maybe further face the liquidation of the company.
All right, ma'am. So there are some questions which are challenging the concept of IU, but I think that we can take it later on.
No, I will.
No,
So
ma'am,
in
I think
that,
ma'am, I think we can take that later on, because we are here to discuss the entry cases and not challenge the concept itself. So Arun has asked a valid question. Can I produce information from IU in arbitration proceeding as evidence?
absolutely every platform.
RTI के तरह valid रहता है ना information IU का?
Absolutely every platform. Rather, IBBI would love to encourage people to come up. You will not believe, now companies raising IPO, or companies raising public deposit, they have actually approached IBBI stating that we want to put in the information related to the funds that has been raised. Or for that matter, states like Tamil Nadu and Maharashtra are already in terms with, and it will encourage rest of the states as well, in order to upload their tax dues. Very soon, people who's defaulting into the tax payment will be flashed under IU.
All right. Thank you. Great answer, ma'am. So, ma'am, to a lot of extent, ma'am has also answered how lawyers can take advantage of information utility. But just for the sake of making learnings more easy to consume out of the session, making it them more articulate, can you tell us in pointers, just in pointers like 1, 2, 3, 4, how IU is in, how lawyers can exploit information utility to the best possible advantage?
Depends what kind of lawyer are you.
IBC lawyer.
Okay, so what happens is, there are corporate councils. There are corporate councils. Very soon, if we are going to have the information about the mismanagement and all, then one can always have access information on IU as per the mismanagement, if at all is happening. Suppose I want to get into, I am an operational creditor, and I want to get into into a turnkey project, or I want to get into a turnover. So the gentleman who had picked up the example of doing the title search of the property, same would like to happen when big shot companies are trying to get into why only turnkey or joint venture. Suppose about merger and acquisition, for that matter, or VC funding, for that matter. We need to work upon the company that we are about to engage with, and we need to have that homework. IU gives you the platform. See, Anubhav, at the end of the day, it is all about money, how it has been handled, and how it will become a machine only to produce further, not to face losses. IU gives you that platform where the information provided as far as the finances of an entity is concerned, it will never be questioned. So corporate councils of such big entities, they will be benefited because they'll be getting information.
Pointers, please.
Yeah, so that is one. Corporate councils will be benefited because they'll be doing such research, ground research, and digging deeper about the company which they are about to engage with. That is corporate councils. Of course, IBC lawyers, because insolvency professionals as well as the lawyers, they will have information. If supposedly I am a representative of a financial creditor, and I get this information, it increases my chances to, establish the fact before the NCLT and adjudicating authority and get the relief. So IBC, definitely one is benefited. Company secretaries or CAs will also be benefited, because it is at the end of the day, if you are having access with balance sheets, there is something called financial audits. And also for the fact that all these government organizations like SFIO or any other organization, SEBI for that matter, they're all trying to engage so that their legal representatives get access of IO and have this information, first-hand information about the companies. And of course, debenture trustees and all are also into picture now. So anyone who is a legal counsel in any of these government organizations or the companies will be benefited, because you get first-hand information. I just expect that, very soon when we have information about the mismanagement of the companies, then it will become part of the due diligence as well. Now, why only this? Suppose there are corporate counsels who are from the other side. Suppose there are corporate counsels of the company debtors. They want to tell their story. So there is a counsel who has been told that SBI and PNB and UCO Bank has put up certain information on IU, and which is adverse to the actual facts. So as a lawyer of that company debtor, suppose I'm working for a company, say any company, say Liberty Shoes or something like that, and I've been told that such wrong information has been put on IU, and I have got the intimation from IU whether this information is authentic or not. So as a lawyer who is representing the company debtor, it is my duty to actually refute and tell what the actual information is. So on all across platforms, IU will not only help lawyers, it will also help insolvency professionals. And it is the aim of IBBI to actually take first-hand information, not only lawyers, CAs, CS, IPs, and put the information and be relieved. So that for years to come, if someday later, some year later, few years down the line, somebody's question, you say that, you can always have access of the information, and better not drag me into some unnecessary legal dispute.
All right, ma'am. All right. Okay. So, ma'am, you told me, I remember in one of our conversations, you also mentioned of NESL, National E-Governance Service Limited. So, correct. Arun has asked a question, something around it. Is there any statutory provision which mandates that any information collated from IU shall be authenticated and can be produced as an evidence?
I missed out the first. Is there any what?
Is there any statutory provision which mandates that information collated from IU shall be authentic and can be produced as an evidence? First question.
Definitely. Refer to IBCI, all the regulations.
Yeah. And second one is, in the absence of this statutory provision, there is no absence. So now next question is not important.
Statutory provision. Now they made it compulsory. If NCLT is saying that if you have to come to the court, you better bring the information downloaded from the IU. It means the retrospective step was they made it compulsory to give the access. All the financial creditors had to give the access, and all the person is thus asked to have that information with them before they come to the court.
All right, ma'am. I think I should not put this, but as there are a number of questions who want to answer, who seeks answer to this question, how is the safety and authenticity of data is preserved on the platforms like IU and NES?
This is what it makes different and exclusive in its own manner, because what we do is, supposedly, I just want to take SBI and LawSikho example for the sake of clarity. Presently the tie-up is with Tata Securities. This is the only, anything that is new in nature comes up with its pros and cons, right? If the pros is I get information and it will be first-hand information, cannot be refuted, I also know deep down that my financial information is being exposed to data theft or data leakage, and there is some questions about the data security as well, because if there is technology, there are hackers as well, not only ethical, but every kind of company, and then there is dark web and all of that, and thus an information which is as secretive as the finances of the company, people might just have that hesitation in actually furnishing the information. That is why, as mentioned before, NECL does not have access to the information. B, the entire setup has been taken care by Tata Securities, which is uptight and which is has not come up with any hacking as of now. Fingers crossed when we have our excellent hackers, working their brains out. B, as far as the authentication and verification, as far as that is concerned, many of us now know it that your signature can actually be challenged in the court of law.
It's 14 hours.
It can also be challenged even if it has been given in handwriting by a handwriting expert, or even it can be challenged until unless you want a CFSL report. But as far as your digital signature is concerned, I hope most of you who have digital signature must be knowing that one cannot use digital signature without consent. It asks for your consent, and only then you could let the other person use the digital signature. So most of the people, what they do is either they use it on their own, or their CA or CS or secretary has their digital signature, and then they seek permission, and then whatever information you put in, you can always at the end of the day, at the end of the document, you can put in the digital signature. So digital signature is authentic. It asks for your consent, and only then such signature, and when I put signature, I give my consent here by saying that all the information given up there is valid and true to my knowledge. Correct? So once it is authenticated, and as far as verification is concerned, I have told many a time that it is not some one-sided story earlier like banks used to do or NBFCs used to do. It is giving information to a platform, and it is being asked by B whether this is true or not. If not, tell us now. We'll put this in the category of disputed. You can always going to the court and having a remedy is not striked out. There is always an option to go to the court. Correct? It's just that to minimal, damage is done to both sides, and saving a lot of time, this kind of platform has been set up. If at all I am asking you that I have put in this information, you tell me. Otherwise I'm going to broadcast it to everyone that you have done this wrong, and if you do not answer, it will be deemed that you're accepting it. If I refute it, then I've been given a chance either to authenticate and verify that whether such dispute has happened or not, or I've been given chance to explain and resolve it amicably, or I've been given chance to put it in the category of dispute and challenge it in the court, or I've been given chance to sleep on my right and face the repercussions in future. But in all the cases, except for the fact that you don't answer at all, you're actually putting in your signature as per the Information Technology Act 2000. So people who are about to put in all of this, they are expected to be technologically advanced. Because if I can do certain kinds of fraud being technically so advanced, I should also put up my side of story by being technologically advanced.
Precisely.
Why only use such technologies for creating scams? Why not use it to put in a strong financial background of my company before any of the stakeholders of who wants to come up and engage?
So ma'am, does this NECL have information pertaining to the partnership and proprietorship, or does
Yes, they're working on it. Not as yet.
okay, or does it deal with the information given by operational creditors?
Oh yes, they do. Very much so.
All right.
Very much so.
All right. So another some repetitive questions in the chat box. Let us skip them. Amidst the COVID-19 scenario in the country, how will the resolution mechanism for individuals will stand in all this havoc?
Resolution mechanism of an individual will stand. Okay. So as far as the individual is concerned, we all know, and we all each day are kind of experiencing what financial instability we might have been facing right now, or we might just face in near future. What has been done by the banks is the amount is too less as of now. 63 lakhs of the amount has been, the information pertaining to such loan amount has been uploaded on IU, and the process is still on, and they're working day and night wherein they are trying to put the information, loan amount, and all kinds of financial informations about the individuals on the IU. And both you and I and the people who are part of this session know that if at all 17th May 2020 order wouldn't have passed by the finance ministry. It is just, it has not been given a shape of the ordinance. It is just a proposal saying that they want to suspend IBC for 1 year. Let's see if the ordinance is passed and it has been approved. It is just a kind of a suggestion. Uh, as an individual, if my financial creditor raises the dispute, and if at all this is not approved, the suspension one supposedly it is not approved, supposedly one can actually go before NCLT under IBC to declare a person insolvent. Supposedly this happens, one can very much realize that the court will be flooded with cases against individuals insolvency. And when it comes to that, such concrete information will be helpful in either admitting or denying or expediting the closure of insolvency cases against every individual. Because we know as an individual, the court is bound to give ample opportunities to prove your stance, so much so that it only takes away the time, energy and money out of the pockets of the person who's fighting and also the person who is being represented, including the legal fees and all of that. When this information is being put concretely on the platform of NECL, it expedites the information, same as in the case of the companies. And in case if a lot of cases do take up under IBC in the near future, then this will come very handy.
Understood, ma'am. So I'm speaking of this order, May 2020 order. What will be its impact on NCLT and IBC practice for lawyers?
So as far as Section 7 application is concerned, earlier we had to make sure that when it comes to establishing the default before the NCLT, we had to prove A, it wasn't a pre-existing default, B, the default has happened, and once the file is being represented before the judge doesn't make a sense, before the adjudicating authority doesn't make a sense. One had to establish the default, and only then the status of the application was to be admitted. And it took more than a year at times in most of the cases. After the 12th May order, you can only enter the court once you have the information of the IU beforehand. Now, taking a step back, IU has the information which is acknowledged and admitted and is the legal evidence of the dispute accepted by the corporate debtor already.
Understood.
So as soon as you reach to the court with the information of the IU, it doesn't take much of a time. It won't take much of a time from now for the courts to accept and admit it immediately.
Great answer. So the first, what I have got from this answer is, one, the filing procedure will expedite. Secondly, all the information is available on one portal, sometimes what happens is lawyers are themselves not prepared. So that time will also get cut it down, and it will lead to executive efficiency. And
not only that, financial auditors and insolvency professionals will be very much benefited. And at the end of the day, of course, we as lawyers will be representing, will be feeded by the data, given by the IO. And I can also have access and check. And, if they are not available, I can't just buy out time. I can just have access and report it. And then, of course, yeah, I can't take adjournments any further.
Hi.
Questions coming up.
All right. There is a lot of positive feedback in the Zoom chat box. I was just looking at it and getting flabbergasted. Wow. All right, ma'am. So we have discussed how the prevailing COVID-19 crisis are going to affect the resolution mechanism for individuals. So is the record of default meant for NCLT?
Definitely. Record of default.
The one you mentioned.
Record of default is for NCLT.
All right. So what is the difference? What difference has IBC brought in how IU, when compared to previous litigation, has brought improvements?
Let us go back to what kind of legislations we had. post 91, financial crisis, we wanted some sort of legislation which could strengthen the power of the banks, the lenders. And that is why SURFACE and DRT and prevention of money laundering came into picture, and where they were given constructive notice and demand notice and all of that. But then, despite of having several legislation spread across under so many acts, we still weren't able to wrap up things quickly. We still weren't able to convert our NPAs into something profitable. We still weren't able to, get the asset reconstruction companies get going and do the bidding and convert a dead property into a profitable one. Something, one in the hand is better than two in the bush kind of a situation. What IBC has done is it has brought everything under one platform.
By IU.
By IU. The NCLT says that you better don't come up to me with half knowledge. You resolve it at your own level, and don't say that you need an arbitrator or something. You need not pay the cost of the arbitrator. You need not be dissatisfied by the arbitrator. One of them will say that, yes, you haven't paid this much amount. This is the pending, or this is the condition. This as per our records. If you want to refute it at that stage. If you don't, then agree to it. And after that also, if there is a dispute, you better come up to me. I have a concrete. So the adjudicating authority also needed a comprehensive, holistic document which had an overview about every party involved. Not some one-sided story which is obviously had to be disputed by the other party and stretching into long number of years.
Understood, ma'am. So I'm a very obvious question by all the discussion. First of all, I would like to ask you, we have already exceeded the session by 10 minutes. If you allow, can we take it further?
Of course.
Thank you so much, ma'am, for
Solar
the extra
eclipse
time.
outside, what else I could have done?
All right. So is NECL prejudicial to financial creditors by any means? And can corporate debtors file information under IU?
No. And that is what it makes NECL. No. Yes to the second part, no to the first part. It is not prejudice towards creditors. Let me just take you back to the story again. So before IBC came, the impression was that all such laws were tilted towards the debtor, because you can do the fault and be done away with it. And all these financial creditors are chasing you and running after you for payments, and you're absolutely fine by it because the matter is pending in the respective courts, be it any court. After IBC, people might have this impression that, oh my God, like eagles or vultures, these financial creditors will just lobby against me, and they'll stand all together against a corporate debtor, which is not the case, because you are given fair share of chance to establish, dispute, or sleep on your rights as per your choice. You are given a chance, and you're also given a chance that whatever information you're trying to put is authenticated by you later, or your representative, or your lawyer, or whatsoever. So you are given fair share of chance. So of course the corporate debtor can log in. As I was trying to say, that those counsels who are working for the companies, every company works on the basis of investments and lendings, and any company made it big because of investments and having financial aid from lenders. So as a corporate counsel representing the financial debtor, it is my duty to keep myself upright as to what knowledge or what impression my financial creditors have, IU being the platform now. And if at all there is any dispute, I should sit down and finish it off. I should resolve the issue. And thus I would not say that it is biased against the corporate debtors, because you're given a chance.
Understood, ma'am. Nicely answered. So if this is a story, then how does the default of record works under IBC?
So what happens is, as soon as one has the default of record, they have reports to it. They also have a report to it. Okay, day one, the information being fed by financial creditor. Day two, email being sent to the corporate debtor. Day three, mail being received at the authentic email ID. Day four, no reply for first 3 days. Let them send another information, another intimation. After 3 days, again, the information is being sent. If you do not reply, then the financial report is being, made up against you, good, bad, ugly, whatever it may be, and it is being broadcasted. It is very healthy for any financial creditor to know the day-to-day working of the company, because globally, if there are people who are into mismanagement or are insolvent or are faulty creditors, they've been treated by little arm twisting all across the globe. I'm not saying there is no corruption outside and all is just gaga in every other country. Of course, there is jod ka tod everywhere. So, but then the thing is, they also have this arm twisting mechanisms when it comes to such faulty creditors. As far as India was concerned, before this, there was no consolidated sort of a platform where all the consortium of the banks can come together and discuss the financial viability of, as I may call it, of a particular entity. So, as far as the financial credit report is concerned, one can always have the liberty to have access, sit down, discuss, break it into pieces, or maybe have a graph being made, extract certain financial information, do the analysis, and then decide where is it going, because it is so crystal clear. And that is why these reports being generated by IU are of pivotal importance for both financial creditors and also the corporate debtors.
Understood. Great. Nicely answered, ma'am. So I have only 2 questions left with me. There is one question someone has asked. What is credit facility report?
Credit facility report. Okay. So credit facility report is usually generated by the IO, which is basically comprising of the credit monitoring. Once I am getting the consent of the debtor, which comes after the regulation 23 compliance of IBBI regulation, I can generate a facility report stating that yes, so much so amount was invested, so much so amount was paid, so much so amount is left, so much so amount is disputed. Such particulars are the dispute with the operational creditors, such particular are the dispute with financial creditor 1, financial creditor 2, or there is absolutely no dispute with the operational creditor. Whatever be the crux of the report might be, this credit facility report is broadcasted to every creditors of the corporate debtor, and their comments are also taken on board. This is not one-sided. Please remember that information utility is an excellent platform only for the reason because it is a two-way process. Your chances are shut down only when you're sleeping on your rights. Otherwise, you have all the right to sit down and dispute or buy out time. Of course, this is new, and once IU comes into picture, it will face its own fair share of challenges, which we might not decipher right now because it hasn't come into full flow. It will only come after 12th of May, and considering only urgent matters are being taken before the NCLT or the pending matters, we'll have to see and monitor as to how things will take place now, when every Section 7 application will be having IU report. And report is nothing but the credit facility report.
Understood, ma'am.
So we will have to see. We can't be prepared for we will have to see how it works. It has been made sure that, if at all there is some kind of default be done, it is a nip in the bud. And if it is not, then a fair share of chance to both the parties should be given, as I'm repeating it time and again. And this is what makes it smart way of knowing the credit system and having that credit discipline in the economy. So once this credit facility report is given, it at the end of the day, there is just one platform. It is not the information is not scattered everywhere. Just one platform for all the financial creditors, which comprises of your banks, your loans, debentures, your bonds, your commercial papers, in fact, public deposit, everything has been brought under one concrete platform. Great. And an average facility report shall be made out of all of this information, which will be like, if not a Bible, then at least some concrete go-to information when it comes to finances of the company.
Understood, ma'am. Nicely answered. So, ma'am, what is Samadhan portal for MSME, and how does Samadhan portal coupled with the IU can help stakeholders expedite the legal proceedings with respect to the defaults of payment?
Okay, so as far as Samadhan was concerned, when it had kicked off some time back, it had faced certain, negative impression because it wasn't working in a way it was supposed to. But then with the coming of IU, it will be very, very beneficiary under the medium and small scale enterprises. Samadhan is a portal under the MSME ministry, which helps people to generate the information, if at all. So, let us come to how the operational creditors work. The operational creditors have manufacturers, they have traders, they have a customary financial cycle of 1 month. If there is one defaulty payment, your financial cycle is being slowed down, and it eventually might stop. Your money goes down, and after a time your operational cost goes high, so much so that you need to fetch an amount from your savings, and you have to get the things going. So apart from the financial creditors, when it comes to operational creditors, uh, it was a requirement where we needed that there is a single default, it is reported immediately, and it has been taken care of in expedite manner. What IU does is, it is one of the byproducts of IU, by the way. It generates the demand notice on behalf of the operational creditor, and it sends it to the corporate debtor asking for so and so amount. The information again of the demand notice is concrete, because it goes through a similar process of that of how the financial creditors puts in the information. And once that information is being put through Samadhan portal, MSME will be benefited, because all these operational small and medium enterprises will get to see some relief, that I need not drag every trader or every manufacturer or every retailer to the court for single payment. We have summary procedures, we have commercial suits, but then nothing has been as fast as how demand notices are being generated under IU. And I just hope that in the near future, every MSME shall pick up information from IU and make it a say a protocol of sending a demand notice through IU, and not just drag the matter and take the other party, for small petty amounts as well, to commercial courts, or for any kind of summary procedure, or such kind of cases. Lot of we have so many dishonor of checks cases where in order to get the operational cost being taken care of, what one does is one postpones the payment, which gets the other person be suffering a lot, because his operational cost, his operational working of the system of a factory or an industry or whatever that is, comes to a halt, or he has to put in his own personal funds into it to make it running. All of that will be benefited once the IU generated demand notice shall be sent on the behalf of the operation creditors to the financial debtors.
All right, ma'am. So this was all for me. I'm done with my set of questions. Now I will invite the questions from attendees. So people, I have enabled this option. You guys can now unmute yourself and ask your questions directly to Somya ma'am. All right. So anyone has any question on YouTube? Are there any questions? No. Same iterative question. If anybody has any question, Farheen, you have raised your hand for quite a long time. Now I'm unmuting you. You can ask a question to ma'am. Farheen, are you there?
I think
I think that is by mistake. Yeah.
It's still being muted.
All right. So there is one question. How does NECL digital data execution facilitate the ease of doing business? Have you answered it, ma'am?
I think the crux is exactly what the same is. I have answered it, and I answer it in brief again, so that the concept is, very clear with people. Uh, if the financial cycle of any company is fast, the ease of doing business again becomes fast. If the financial report is crystal clear before any person who's about to invest, the ease of doing business, where when it comes to ranking, let's say India ranks very low when it comes to ease of doing business. In the past few years, you might be seeing that Ministry of Corporate Affairs has done significant changes when it comes to ease of doing business in India is concerned. But then I think there is a long way to go, and IU has just been dropped in time, where a concrete, crystal clear, undisputed, authentic financial report of a corporate debtor is available. And thus, it'll be easy for any business entity to make a decision whether to go ahead with certain corporate debtor or not, and thus helping these investors or financial creditors and operational creditors in having ease of doing business.
All right. So people, I think seeing no questions, Somya ma'am, you have clean, bold every prospective query.
Thank you.
So
There's a lot more to discuss, Anubhav. There is a lot more to discuss, and I'm excited to see what happens as soon as the court is open in full-fledged manner, and what kind of, of course, there are going to be certain glitches. I would want to see what kind of glitches we are going to face as far as this platform of IU is concerned. And for that, we will have another session maybe.
sure. I'm telling you guys that you can unmute yourself. Let me unmute you. Debashish, you have a question, right?
Yeah.
Yeah. Please go ahead.
The question is regarding whether this IU facility is available to lawyers free of cost, or is it against a particular fee?
No, so this facility is available to lawyers free of cost, because the brainchild is of lawyers, so we can't afford to ask for a fee from our fellow brothers. No, jokes apart, you have to pay a fees when you have to store an information, like you pay for iCloud. Whosoever has an iPhone pays and buy out that space on the iCloud. The rate is much cheaper though, and you can store your information for 8 years. So one can always store the information, and you have to pay a minimalistic cost to it. But then as far as having access of the information is concerned, it is free.
Thank you.
Next question is from Sushil.
Yeah. Can you hear me?
Yeah, absolutely.
Yeah. I was going to ask you, what will happen in case there are multiple IUs? Will the information be shared amongst them?
I didn't get this question.
Okay, yeah, I get it. So
Please explain it.
I'm glad you actually raised this question, because people might get confused as to what IO is and if there are multiple IOs. So IO is one.
Hello, Somya ma'am.
Can't hear her.
I think we lost her, right?
Yeah, I'm not able to hear anything from her.
There is a little technical glitch. I think her internet got shut down. Just give us her minute.
I think my
She will
question
be
was
right
very.
back.
My question might have been too tough.
No, not really. She was about to answer it.
I'm just joking. Yeah.
So, ma'am, are you there? No. Let me fix it. Let me follow on WhatsApp. Is she back? It's a technical glitch, boss, because I am also not able to connect her on WhatsApp. Her internet is showing shut. So, all right, people, I think we can call it a day. Let me just give you Somya ma'am's email ID so that you can reach out to her in case of any unanswered query. Just give me a minute. I'm typing it in the chat box.
You're entering it in the chat box, is it?
Yeah, I'm just sending it to you. In the meantime, why don't you guys give me a quick feedback? Please rate this session on a scale of 1 to 5, with 1 being the lowest and 5 being the highest, so that I can get a sense of how we perform today.
वो क्लोज कर रहा
हाँ मैं इसमें क्लोज कर रहा हूँ आप
है
फीडबैक
5G कर रहा हूँ कनेक्ट नहीं किया इंटरनेट
All right, feedback, people, feedback. All right. Somya ma'am का email ID. Just give me a minute. Got it. So yeah, here is Somya ma'am's email ID. You guys can get in touch with her for all your doubts. Now, okay, everyone has got it. I will also be circulating it in our WhatsApp groups. So thank you so much for joining the session. I also learned a lot, and it was really fun interacting with you guys. Your questions were really insightful. So with this, thank you, people. Break a leg. Have a good day. Bye.